Now I'm going to explain Section 3 of the Arizona Residential Purchase Contract, Title and Escrow. This section is particularly important for first-time homebuyers to understand. Let's start with escrow. When you enter into a purchase contract, you'll select an escrow company to act as a neutral third party. This company will collect your earnest money, coordinate document signing, and ensure all conditions are met before the property changes hands. The purchase contract itself serves as the escrow instructions. Next, let's talk about title. Taking title refers to how you'll legally own the property. If you're married but want to take title as your sole and separate property, you might need a disclaimer deed. This is an area where you should seek independent legal and tax advice, as how you take title can have significant implications. A critical part of this process is the title commitment and title insurance. The escrow company will obtain a title commitment, which is essentially a promise to issue title insurance after closing. This document reveals any issues with the property's title, such as liens, easements, or deed restrictions. You'll have 5 days after receiving the title commitment to review it and notify the seller of any items you disapprove. The seller will convey title by warranty deed, subject to existing taxes, assessments, covenants, restrictions, and other matters of record. At closing, you'll receive an Alt-A homeowner's title insurance policy, or a standard owner's policy if the homeowner's policy isn't available. This insurance protects you against title defects, and the seller pays for this standard coverage. If you want extended coverage, that would be at your additional expense. Section 3 also covers how taxes and assessments are handled. Real property taxes will be prorated to the closing date based on the latest available tax information. Other assessments and fees that aren't liens at closing, like HOA fees, irrigation fees, or service contracts, will also be prorated. If there are assessment liens or bonds, such as those from a community facilities district, these amounts will be prorated at closing as well. The contract also addresses what happens if there's a dispute about your earnest money. The escrow company is authorized to release the earnest money according to the terms of the contract, and both buyer and seller agree to hold the escrow company harmless in such situations. One final note: if the property is in a homeowners association, the escrow company will notify the HOA of the pending sale, including your name and address as the buyer. Understanding these title and escrow provisions helps ensure a smooth transaction and protects your interests as you purchase your new home.